For today's United States Supreme Court case, we look at a situation in which a person takes on the mantle of being the United States government and wants to sue, and the United States government itself also wants to get involved in the same action. So this is what's sometimes called as a private attorney general, where a person has the right to act on behalf of the state in the name of the state. It's as though the state themselves is suing, but it's a person doing it that is authorized by state but not otherwise affiliated with the state. This is very common in California. They have this Private Attorney General's Act, which broadly allows for this. United States law also allows for this in much more limited circumstances. It's a benefit to the United States government and the governments that allow it because it allows for private enforcement of laws and also allows the person who sues to get some of the money, but the US government also to get some money. So it allows enforcement of law without any effort by the United States government to enforce the law. It's basically a bounty program, right? You bring us this case or you prosecute it for us, you get money, we get a cut, you get a cut, everyone wins, the law gets enforced. All right, so that's one of the things we're doing, right? This guy Polansky is suing in the name of the United States. He is the United States, but the United States government also wants to get involved. So how does that work? Let's learn a little bit more about this. The False Claims Act imposes a civil liability on any person who presents a false claim for payment to the federal government. You can't lie to the federal government that they owe you money. The statute is unusual in that authorizing private parties to sue on the government's behalf. That is a little bit more uncommon in federal law. It is relatively rare. California seems to allow for it fairly extensively, federal law in very limited domains. Those suits, which are known as qui tam actions, that are brought in the name of the government, and the injury they assert is for the government alone. So it is the government's injury. They're suing in the name of the government. The government is the one that's injured. They are taking on the mantle of the government. But in one sense, a qui tam suit is for the person who's suing as well as for the government. If the action leads to a recovery, the person who sues gets 30%. So there's the bounty, right? The US government could bring this action itself and get 100% of the proceeds. But the US government doesn't want to be bothered necessarily with having to do all this on its own. So it's like, okay, fine. We'll offer a bounty. Hey, you, private individual, would you like to enforce our laws for us? If you do and you win, because we exerted absolutely no effort whatsoever, but it is our laws, we get 70%, you get 30%. What a deal. Well, it can be quite a deal, actually, because sometimes those damages can really add up. So 30% is a finder's fee, maybe not so bad. Some people want to take that deal. This is what this guy wants to do. Because this guy is not an ordinary plaintiff, he's subject to special restrictions, right? He's not suing on his own behalf. He's suing on behalf of the government, so it comes with some special rules. He must file his complaint under seal and serve a copy and supporting evidence to the government. Because it is the government's cause of action, it is their lawsuit, the government gets a copy because it's their cause of action. You're just borrowing it. The government then has 60 days to decide whether to intervene and proceed. So the government can be like, oh, that's an interesting lawsuit, yoink, it's ours. So we'll take it over. Now that you've done all the legwork and all the sort of background necessary to get this lawsuit started, yoink, it's ours. So you get nada. All right. So that's a risk of the thing. Otherwise, the person who sues gets the right. But even if the government passes on intervening, it remains a real party in interest. So again, the government has this period to decide, okay, yoink, our lawsuit. But even if it doesn't, it is an action on their behalf. It is fundamentally their cause of action, so they remain an interested party. More relevant to the issue here, the government can intervene after the period ends, so long as it shows good cause. So even after the period ends, they can still get involved if there's a really good reason. So you can do it for no reason for a limited time, and then for good reason after that. So in this case, Mr. Polansky over here filed the action in the name of the United States, alleging that the respondent, Executive Health Resources, helped hospitals overbill Medicare. The government declined to intervene during the period, and the case then spent years in discovery because that often can happen. Cases sometimes get dragged out. So the case went on in discovery hell. That can be a thing. Eventually, the government decided that the varied burdens of the suit outweighed its potential value. So it filed a motion for which the government may dismiss an action notwithstanding the objection of the plaintiff, so long as the plaintiff received notice and opportunity. So the government over here, after years and years and years of this going through discovery hell, and this guy incurring all kinds of costs in time and lawyers and all the rest of it, the government took a look at all this wonderful effort that the guy had been building and decided, you know what? We don't think the juice is worth the squeeze. We don't think that the amount we're going to get out of this is worth the effort. So let's just dismiss this completely. We don't think this is a good use of time. Even though it's your time, we still don't think it's a good use of time. So we're going to move to dismiss. You get nothing, but thanks for the effort and all. The district court granted the request, finding the government had thoroughly investigated costs and benefits and come to a valid conclusion. So yeah, no problem. You didn't intervene during the relevant period, but later you're like, this isn't a good use of time. Let's dismiss. They say, fine, dismiss. The guy gets nothing. Okay. The Court of Appeals for the Third Circuit affirmed after considering two legal questions. First, does the government have authority to dismiss an action under the relevant paragraph if it declined to intervene during the period? So if it intervened during the period, yoink our lawsuit, then it could be like motion to dismiss because yoink our lawsuit. But it didn't do that. It didn't say yoink our lawsuit. So can it file a motion to dismiss? The Court of Appeals held the government has the power to do so as long as it intervened sometime later. So as long as there's a good reason, then yeah, that motion to dismiss will be fine anytime. And the court found the government has satisfied that condition here. Second, what standards should the court rule on the motion? The Court of Appeals held the proper standard comes from the Federal Rule of Civil Procedure, the rule governing voluntary dismissals in the ordinary course of litigation. So there's a standard rule on how to dismiss a lawsuit, and they say, okay, let's just use the standard rule that's in the book. That's fine. And here the Third Circuit ruled the district court had not abused the discretion in granting the government's motion. So after years and years of discovery hell and time and energy wasted and lawyers used and retention and documents exchanged and argued about, lawsuit go bye-bye. No one gets any money. The guy's sad. So is that legal? Is guy sad legal? Let's find out. Oh, the government may move to dismiss the action under the relevant law whenever it's intervened, whether during a seal period or later on. So yeah, this is one of the problems. It's not your cause of action, really. You're just borrowing the name of the United States because we let you, but it's really our lawsuit fundamentally. We were going to let you do all the legwork and pay you 30% at the end. But we have the right to intervene because it's fundamentally our lawsuit. We were just letting you kind of borrow, and we decided we didn't want to let you do that anymore. And we have a really good reason because we looked at all this wonderful discovery that you've gotten now, and we've realized the juice isn't worth the squeeze. So we have a really good reason to intervene and a really good reason to dismiss. Supreme Court yeah, that's cool. All right. So the government contends it may move to dismiss under some paragraph 2, even if it's never intervened. The relevant paragraph refutes that idea. So you can't dismiss without intervening. You can't do that. You got to intervene. Unlike other provisions, paragraph 2 does not say it applies when the government is not a party. So some other paragraphs do say the government can do things even when it's not a party because the relevant law says that. So the government can prevail only by implication, and the implication does not fit. The relevant paragraphs grant government uncommon power to dismiss and settle an action over the objection of a person who brought it. So yeah, the government can do that in some situations. That sort of authority would be odd to house an entity that has continually declined to join the case. And subparagraph C and D presuppose the government has intervened. Subparagraph C enables the court to restrict the person's role, the plaintiff's role, when needed to prevent interference with the government's prosecution of the case. And subparagraph D allows the court to restrict the person's participation if defendant would otherwise suffer an undue burden. Here, the premise is the government has joined in the case, else the court would be limiting the role of defendant's sole adversary. Zoom out to the rest of the statute, and the government's intervention is irrelevant. Case looks even weaker. The relevant law addresses the rights of parties and contains 4 relevant paragraphs. Paragraph 1 states it applies only if the government proceeds with the action, something the parties agree cannot happen unless the government actually, intervenes and proceeds. So there are things, what happens with the government proceeding, but that would require the government to proceed. The paragraph concludes by stating the realtor may continue as a party subject to limitations set forth out. It thus states that when the paragraph situation obtains, the plaintiff's role will be limited in ways set out as paragraph 2. And paragraph 1 situation applies only when the government has intervened. So that's also when paragraph 2's provisions, including the one about dismissal, kick in. In other words, the express intervention prerequisite of paragraph 1 carried forward into paragraph 2 through the subject to clause connecting the two. Only when paragraphs 3 and 4 are reached does the necessity of intervention drop away, as those paragraphs, unlike 2, specify the circumstances in which they apply. Paragraph 3 applies when the government elects not to proceed, and paragraph 4 applies whether or not the government proceeds. And just to pile on a bit, the government's alternative construction creates surplusage twice over, violating the interpretive principle that every clause and word of a statute should have meaning. So absent intervention, paragraph 2 does not apply, and they can't file a motion to dismiss. So sometimes the statute does allow the government to do stuff, even though it's not a party, because it's really their lawsuit, right? So they can move to dismiss even though they're not a party under some circumstances, but not this circumstance, right? So the statute seems to create this scenario. It seems to create a scenario where, okay, if the government elects not to proceed, paragraph 3, great. Paragraph 4 applies either way, but paragraphs 1 and 2 are separate paragraphs, and Congress made choices. So yes, U.S. government, you might have the ability to unilaterally dismiss this thing, whether you're a party not under some circumstances, but we're not in that circumstance. So no, you actually have to intervene first. A straightforward reading of the relevant law refutes the plaintiff's position that paragraph 2, as linked to paragraph 1, applies only when the government intervention occurs during the sealed period. So he'd very much prefer the government not be able to dismiss unless it's during that limited period. Not for the least of reasons that as much work and effort as he's done bringing the lawsuit to bear, he's done exponentially more work in the discovery process. Discovery can be a complete and total pain in the ass, and often is where the bills get really racked up. Because if there's discovery fights and there's a lot of discovery and stuff, that can be really expensive. So whatever expense he incurred in bringing the lawsuit, which was not zero, is dwarfed by the amount of damages he incurred from the discovery. So it's like they can't move to dismiss now. They could only move to discuss before discovery. Look at all the new expenses I've incurred. So I'd really prefer them not to be able to dismiss. Recall the government can intervene either during the sealed period or at a later date upon showing of good cause. A successful motion to intervene turns the movement into a party. Yes, if you intervene, now you're a party. And once the government becomes a party, it, alongside the plaintiff, does what parties do. It proceeds with the action. That phrase again is the trigger for paragraph 1. When the government proceeds with the action, it assumes primary responsibility. So now we are involved in the case, and we are the principal party. We are the principal party. So guess what we get to do? We get to move it to dismiss because we're the principal party. So, yep, that's how that works. And for the reasons above, whenever that's true, paragraph 2 also kicks in. So the right to dismiss under the relevant subparagraph attends in later intervention just as the earlier one. So if the government intervenes at any time, at any stage, then you know that. The plaintiff over here, who is very, very sad about all the time, energy, and fees he's undoubtedly incurred, his contrary argument mainly relies on paragraph 3, which provides a court approving the government's post-seal period intervention motion may not limit the statutes and rights of the plaintiff. That clause, he argues, prevents the court from giving the government primary responsibility over the suit, including the power to dismiss. But on his reading, paragraph 3 clause would effectively negate paragraphs 1 and 2. The government, even though proceeding with the case, would not acquire control that paragraphs 1 and 2 seem to afford. The plaintiffs, therefore, would put the statute at war with itself, which, we're not going to do that. Instead, the clause is best read to tell the courts not to impose additional extra statutory limitations on the plaintiff when granting the government's motion, ensuring the parties will occupy the same positions as they would have had if the government had intervened. So we're not going to do anything extra to you, just allow them to completely dismiss the case out from under you. And that view fits with the relevant law's government-centered purposes. Congress knew that circumstances could change and new information could come to light. So Congress enabled the government, in protection of its own interests, to reassess the litigation of actions that were in the government's name and join a case without having to take a back seat to a co-party. So if they're involved, and the government gonna government. In assessing a motion to dismiss an action over the plaintiff's objection, the district court should apply the rule generally governing voluntary dismissal suits in the ordinary course of litigation. So let's just go to the standard rule that standardly applies. The federal rules are the default rules, and nothing warrants departure. To the contrary, the relevant laws cross-reference the rules, and the court has made clear that other rules also apply in the ordinary context of this particular litigation. The application of Rule 41 in this context will differ in two ways from the norm. First, the relevant law requires notice and an opportunity for a hearing before dismissal. So, even though we're going to follow the standard rule, which allows for voluntary dismissal. In this particular case, you do get notice and an opportunity for a hearing, which I'm not sure what the point is because they're the primary litigant and they can do whatever they want. But I guess maybe there's some circumstance in which maybe you could argue corruption or something, but good luck with that. I'm not sure what the point is, but okay. Second, in the relevant context, the set of interests the court should consider in ruling on the post-answer motion is more likely to include the plaintiff, as the plaintiff may have contributed substantial resources to the action. That's a bit of an understatement. Yeah, substantial resources indeed. Thousands and thousands and thousands, and potentially millions of dollars, depending on exactly what's going on. Some of these actions can be quite expensive. And if you get locked in discovery hell, it can get pretty costly pretty fast. And there's no coins at the end of this rainbow. So that, yeah, it is a problem. Yeah. But even so, the Third Circuit was right to note the government's motion to dismiss will satisfy the rule in all but the most exceptional cases. So yes, you have a right to a hearing, but you're not going to win your hearing except in the truly exceptional case. So I don't know, the government's been bribed or it's corrupt or something, but whatever that is, it ain't here, even though you've probably spent millions of dollars. That's not exceptional, so no. And here the government gave good grounds for thinking this suit would not do what all suits in the name of the government are supposed to do, which is namely vindicate the government's interest. So we don't really think that this is going to help us very much. So, yeah. Absent some extraordinary circumstances, that short of showing is all that's needed for the government to prevail. Kagan delivers an opinion for an 8-1 court. Oopsies doopsies for a plaintiff over here. Things didn't end well for him. Well, that's sad, I guess. Thus, that brings us to the end of the United States Supreme Court case in which Polansky over here is the United States. He wants to be the United States, don't we all? But the United States says it's cool for him to be the United States. He wants to sue under the False Claim Act. You can't lie to the federal government. And if you do, you're going to get fined and, there's money. Yay, money. The federal government says, okay, we're going to create a bounty program. And Polansky's over here like, okay, that's cool. I'm going to do that. And then spends much time, much effort, and much monies in discovery hell, only for the US government to come along and be like, we don't really think it's worth it, and we want to dismiss. And Polansky's sad because he's out and he doesn't get anything. So that's a bad day for him. So yes, the US government, at least under these circumstances, can intervene for good cause and then can dismiss for pretty much any reason it wants, except some truly extraordinary situation, which I don't even know what that is, but I wouldn't try to find it because it's not going to come up very much. So he's just out his money. And that brings us to the end of discussion of this story.